Good afternoon or morning, depending on where you are joining us from today. My name is Francesca Guerrero. I'm a partner in Thompson Hine's International Trade Practice Group. Today, July 1st, the U.S.-Mexico-Canada Agreement, USMCA, replaced the North American Free Trade Agreement, or NAFTA. This trilateral free trade agreement affects many facets of the North American economy. I'd like to welcome you to Session 4, the last of our 4-part webinar series. We'll be discussing supply chains, issue spotting, tips and best practices for maximizing USMCA benefits. Before we begin, I'd like to share a few housekeeping items. First, today's program is being recorded, and we will send a link to all attendees within 48 hours of today's presentation. If you have any questions during the webinar, feel free to use the question box located in the control panel on the right side of your screen to submit questions. In fact, today's discussion will be a roundtable, so we definitely encourage you to put questions in the question box. In the handout panel, you can download a copy of the PowerPoint slides and bios of today's speakers. Again, thank you for your interest. I'm delighted to introduce our panelists. Joining me today are Alejandro Luna, a partner with Santa Marina and Steta in their Mexico City office, Asha Wanless with Polaris, and Steve Garden with Lear Corporation. I'm now going to set the stage for our discussion by going through some basic information about the USMCA's key dates for implementation. Then I will be moderating a group discussion on how companies are addressing supply chain issues arising from the USMCA implementation. Please feel free to type a question at any time. We will try to answer as many of these questions as we can. Let's get the slide going again. As we mentioned, the USMCA enters into force today. So really, we're just all here for a victory lap to celebrate having all that we've accomplished. But in actuality, we thought it would be helpful to look at some of the past dates so you can understand, where we are today. In April 21st and 23rd, that was when USTR published requirements for the alternative staging regime for automotive items. Mexico was April 23rd. That meant that on April 24th, the U.S. notified the completion of its domestic procedures, and that allowed the parties to set the entry into force for July 1st today. On June 3rd, less than a month ago, USTR posted the uniform regulations implementing the USMCA. That included a number of procedural requirements that are, critical for doing analysis for our rules of origin and other matters. June 16th, Customs issued updated interim implementation instructions, so 2 weeks ago. And then today, here we are with USMCA in force. Tomorrow, disputes may be filed under the Rapid Response Labor Enforcement Mechanism, and there are signs that some people are ready to go. Alejandro, I'm sure, is preparing for that. Just quickly on the automotive staging again. Today, there is a staging period that is a default under the USMCA. If companies wanted to propose an alternative staging plan that would extend the period or move the dates around a little bit, the due date for that alternative staging plan was July 1st, which is today. So, you can have a few more hours to get those in. That would allow you to extend it up to 5 years for the transition time. And then if you have submitted or are submitting today an alternative staging plan, you have until August 31st to submit your final alternative staging plan. That would take into account any modifications based on comments that have happened, or you need to notify that your alternative staging plan would be considered final. So all of these dates in mind, just to make sure everyone is, clear on how quickly things have been developing in the last few months and how quickly they will continue to develop over the next few months. We're now going to turn to the roundtable portion of our discussion. If you have any questions, please feel free to enter them. I will be asking questions of the panelists and, moderating a robust discussion, but feel free to add your own. And so the first sort of theme we'd like to talk about is just understanding the supply chain considerations, what this means that the USMCA is taking the place of NAFTA. And I think we should all answer this one. Asha, maybe we'll start with you. We haven't had very much time to review the new regulations. Again, they came out less than a month ago. How do you think this short time period is impacting companies' shift from NAFTA to USMCA?
I think everyone's feeling the same way, that it is just a ridiculous feat that we're all being asked to do, and we're scrambling, trying to read complex regulations. When you add on top, there's the initial text that was published, and then there's regulations that you have to mesh together and read back and forth. We're seeing rework, maybe some interpretations that we thought made sense, and now we're having to circle back and tell suppliers, just kidding, that's not right. So I think that the short time period is going to lead to confusion, rework, some frustration, and just some challenges around communication and expectations of suppliers.
And Alejandro, maybe we could ask you to discuss that a little bit with a twist that the uniform regulations, I understand, have not been published yet in Mexico, although they have been made public. And also, I'd like to weave in the fact that CBP has informed companies that essentially if you're entering goods thinking that you have USMCA eligibility and you get it wrong, there is the possibility of correcting it without penalty. You have to pay the duty later, for some time period. And I'm curious to know what Mexico is doing, on that front as well.
Sure. Thank you, Francesca, and thank you for having us in this roundtable today. Well, as relates to your question, you're correct. The uniform regulations were made public through the website of the Mexican government and the Ministry of Economy in its English version, actually, on June the 3rd, equally to the U.S. and what the USTR did. However, formally speaking, through our legislative process, in order for such new regulations to actually come into force, they need to be published in the official Gazette of the Federation and in the Spanish language. They've probably lagged behind in the official translation in view of this time period. And because of that, they haven't been issued. So they've been made known, but formally they haven't been implemented. Thus, the general provisions only apply. But at least from a pragmatic perspective, the automakers and the rest of the exporters and importers know the playing field already. That may lead to contest their certain matters, but it would have to be immediate. Probably they'll only lag behind a few days. Difference to NAFTA, where they lag behind for the customs rules to be issued a year and 9 months. Having said that, they did publish general rules or criteria on customs provisions yesterday, okay, and those do complement, and it goes to the matter of certification. Here, actually, the Mexican customs and the Mexican tax authorities and the Ministry of Economy have all said that this comes into force today, and there will be enforcement as to certification, for example. And what that leads us to is we believe that a lot of companies will not have those certificates and delays there, properly addressing them, properly having the minimum requirements that are set forth in the treaty and the rules. And because of that, we believe that certain companies will opt instead to actually pay the duty, which is what the law foresees, and to be able to request reimbursement of such duties paid in a year's time. That is what the treaty provides. It calls for a rectification on the import manifest in a month's time, and then you can request that through the formal process of reimbursement, or you could compensate. You could actually apply such duties to future importations performed, okay, within the next 5 years if you file this rectification within the first year, okay? And that is how we believe this will be addressed from a pragmatic viewpoint. No?
Okay, no, thank you. That's very interesting. Steve, I'd like to kind of move this to you and ask you what you thought the most interesting things, the uniform regulations, most helpful developments were to come out of the uniform regulations.
That's a really good question. Helpful might not be the way I thought of it. I think there was, I have a bunch of different reactions to the regulations, but I think the most prominent one amongst them is I think there was so much expectation built up about what the regulations were going to say. And this is generated as much as by anyone, by the government officials. I mean, I had, USTR officials and even economy officials in Mexico and in Canada and GAC telling me, and I'm obviously in automotive, so I was very tuned into what was happening. And I think the message from all of them was that the text is very, very high level. And you're going to get all the information you need in the regulations. That's going to give you the details you need to operate. So I think they set this bar very, very high, and everybody was waiting, and then expecting it to answer obviously not everything, but a lot of questions. And I think that the general consensus I see, particularly amongst my industry peers in the automotive space, is that there are a lot of questions answered, but there's still just a huge range of open questions. Everything from calculating RVC, the definitions of auto parts, the labor value content. There's still a lot of open questions. And then I think too that in the certain part of the regulations, they almost have no more text than the agreement itself. So. And so there's still that need there. I think for industry still has that need for USTR and CBP and economy in Mexico and Canada and GAC to communicate how some of these rules are going to work that are really critical for many companies. So I think there's still a lot of work to be done. And at the same time, I think we're all in the position as companies that we need to go. Like today, we need to go. And so I think we just have to we're still in the position where we have to make a lot of assumptions on how the rules are going to work. And I think we have a lot of, ways to do that and a lot of assumptions we can rest on, but a lot of it is just going to be, well, this is, for example, like this is the way it was done in NAFTA. So we'll just assume it's going to copy over, it's going to be a copy over to USMCA, right. But I think there's still a lot of open questions, across the board that are going to have to be addressed in the upcoming months, and hopefully, there'll be a real cooperative environment with CBP, with USTR, and with the Mexican and Canadian counterparts that we'll be able to get these addressed in a logical way and be able to move forward long term.
Well, see, I'm glad you're still optimistic, Steve.
Either that or be pessimistic. No, but I think it will be. I think it was a reflection of how rushed it was. I think it was in a different world, we would have had more time to develop the regulations, and there would have been a lot more engagement with industry and a lot more, back and forth where there would have been input. I think they were just very, very rushed. I think everyone agrees. So I think anytime you rush things, you're going to have gaps, and you're going to have, a lot of open issues, and they'll just have to be addressed. And I guess one of the good things about it is that the regs were published, the regulations in the U.S. were published as interim final. So there is a formal comment period that this can at least start to be addressed. But hopefully that open engagement will continue, and issues that need to be addressed will get addressed, in different ways, and we'll get to all where we need to be. But there's still a long road to go.
Right. So speaking of, preparing, as you are reaching out to suppliers about whether they can certify their products under USMCA, and this is for both Steve and Asha, what sort of responses are you receiving? I know there's a lot of confusion. So are you prioritizing your outreach to certain suppliers? Is the process revealing any concerns? Alejandro, if you want to jump in as well, but please tell us how that process is going, given the open-ended nature of the guidance.
Sure, I can start. So we prioritize reaching out to suppliers to have very specific conversations about certain parts to help assess two things. One, their readiness in general, and also to validate the assumptions that we made when we did an analysis where we took our NAFTA analysis, we made some tweaks to it of what we thought would be different for USMCA and said, where do we think we're going to end up in USMCA? But let's validate that these assumptions that we made about supplier qualification is actually valid. We selected those suppliers and those parts based on the highest impact parts, so high value that have a big impact to our vehicle qualification. So those are very specific conversations. We also sent just a notification to all of our North American supply base saying this is coming, get ready, here's the regulations. The responses that we're getting back primarily are what you would expect, which is, boy, we're just still trying to figure this out. What do you want from us at this point? It really is this crazy domino effect where it's really interesting, probably those smallest, lower tier suppliers are probably have the least resources to understand and digest all this information. And the next level suppliers are waiting on their response, and they're waiting on their response. So as an OEM, we're definitely struggling to move as quickly as we need to, given that, surprise, it's today. So we're trying to, engage, educate. We are setting up separate meetings, engaging our sourcing team and the leaders at our suppliers to set up now meetings, one-on-one meetings, to really say, this is important. You have to do this. You may not wait. So, some of the response from suppliers is, we're really busy with the pandemic and with these other things. And so when we're getting that response, that's part of the, nope, this is a priority.
And I think from our side, it's been a similar experience. And I think some of our suppliers, their rules didn't change much. They might have had a pretty simple rule before, like a tariff shift, and they clearly manufacture the goods and transform the materials in North America. So the expectation is it's not a big deal for them to change over and issue a certificate. And we're generally seeing that. But we have other inputs where there is a significant rule change, and the feedback from those, and also too, is where those suppliers are in turn relying on their sub-suppliers to certify before they can issue a USMCA certificate. So we're, the feedback we're getting is along the lines of we're still trying to figure out the new rules. We're trying to do it in a hurry. Please be patient. And also too is that we need our supplier information in order to certify our product that we sell to you, which is a legitimate, which is truly a legitimate situation, and that they can't really rely on that NAFTA cert, or they're very cautious to rely on that NAFTA cert. They can, U.S. Customs has said that they can rely on the data in it, but not the cert itself. So you have this situation where, I think there's a collective effort to try to respond to customers, but it's happening in such a short time, and everyone has real challenges that, everyone's waiting on everyone. And it's going to take a while for it to get back to where it was before, where everyone understands and what the rules are, and they have sufficient time to respond, and it kind of goes back to a routine like it was with NAFTA. I think we're gonna have to go through this for a few cycles of soliciting information before we get there.
And I think to the point that Steve makes here in Mexico, it's been a little bit reactionary. In the last couple of months at the maximum, have people reacted to this coming into force and understanding this pragmatic consequences will be deferred at least 3 years, 6 months until the 1st of January of 2024, that possibility as foreseen under the treaty itself, and we'll need new rules to that effect, and we haven't seen them. There isn't, of course, yet clarity on them, and it'll take them time to do so. And there are even pragmatic matters here in Mexico. One, for example, is the digital signature that is foreseen. Now you can issue them electronically, the certificates, or certifications. They're not really certificates any longer, And it calls for an electronic signature versus an actual signed version in any case, or foresees that possibility. And then the treaty goes on to say that it will be the certifying party pursuant to the rules, but issuing one from here, Mexico, or abroad, such a certification electronically, it's still not very clear what that electronic signature will be, and even the rules that were issued, the general rules on customs provisions aren't very clear on that. So it does have that pragmatic effect, and people will be scrambling in the next few weeks to get greater clarity. The general rules do foresee guidance to be given by the administrative authorities, which is goes to transparency and trade facilitation. That is a lot better under this treaty than what it was under NAFTA 25 years ago. But still, we need to see how the authorities actually react to this type of petitions.
Thank you. We have actually a question from one of our attendees, and I'd like to ask that before we move to some tips. The question goes to what you were just saying, Alejandro, in part. What are companies using as the certificate form to replace the NAFTA form, since there's no USMCA certificate?
Sure. Well, the treaty does foresee that you can actually even foresee it directly in the invoice if it's coming directly from the exporting country or an originating country. We've not yet seen, this came into force today, but there are minimum requirements set forth here in Mexico, at least under the general rules that establish basic minimum statements. And it does foresee that if you include further information, more information that is actually required under the minimum part, that should not hinder or be a reason for denial of that certification by the customs authority. So that is at least an advancement versus the fixed format we used to have. And those minimum rules, in as much as you comply with them, you should be good to go. Okay, but there are pragmatic issues still.
Francesca, just I think an interesting comment that I can make in response to the question is that, you know, I participated in an AIAG, Automotive Industry Action Group, working group on USMCA, and we spent a lot of time talking about this question and, you know, what's going to replace the certificate of origin, and I, you know, what the consensus was really early on with that group, and it was a mix of a number of suppliers and vehicle producers, is that we still, you know, for the industry, we still need a form. Even if there isn't an official form, we still need a form because we still need suppliers to provide us those data elements, which are largely the same. We still need a vehicle to provide those data elements, to provide that certification, to sign that statement that the goods still qualify. So the consensus was that we still need a form, and we have to make up our own, you know, in lieu of one being prescribed by the authorities. So that's what you've seen in the automotive space, is that it's basically the same form. It's been tweaked a little bit, and some companies, particularly the vehicle producers, have tweaked theirs a little bit, like they did with the NAFTA form, to meet their specific needs. But you know, the consensus was you still need that form. It still has to have those data elements. You still need that statement, the certification, and it's signed and all that, just to make sure that the supplier is standing behind what they provide. And that you know, that was kind of the consensus of the industry on what the companies felt they needed to be able to go forward.
Would you see something like trade, because what we foresee here a little bit is guidance by the trade associations, the chambers of commerce and the like, to be issuing? It's sort of like what we've seen under our own agreement with the European Union, where that is foreseen.
Mm-hmm.
And same with us. Our form essentially looks like a NAFTA form. It just doesn't say NAFTA, and it references USMCA. Obviously, you know, a couple columns are removed, but otherwise it's essentially the same.
Okay, no, that's hopefully a very useful answer to the question. Kind of moving on now to some tips that we'd like to share. And Asha, maybe you can start us off. Can you maybe talk about how you're using some of the regulatory tools to manage uncertainty? For example, extended period for averaging, or any other sort of options out there?
Mm-hmm. Yep. So at Polaris, we make off-road vehicles, and we've historically done what's called averaging our vehicles to calculate the RVC at kind of a category level. Averaging is done for a calendar year. There were a lot of concerns that we had because we're implementing a trade agreement mid-year. So we actually worked with USTR and said, boy, can we have an 18-month averaging period for the first period? So that buys us 6 months to get everything organized, and then the next year, and then we'll go back to the year cycle. And I think that was a real interesting experience for me, how receptive USTR was to get on the phone with me and the head of our public affairs group and have a conversation. Interestingly, we had the same type of interaction and receptiveness from USTR when we said, look, we're not really automotive, we're off-road, so we don't want to have to follow all those crazy automotive rules. Can we have our own? And they said, okay, well, what do you want it to say? And we said, we want off-road to be defined like this, and we want our own rules. Literally copy-paste from what we provided on definition of off-road, and we got our own rules. So really cool experience. I want to share that with everybody, that I just thought, you know, I don't know, I live in Minnesota, DC's way off, and who the heck knows who these people are. Not the case. Super engaged, and I'm sure, you know, it's not always the case in every situation, but great. So, you know, lesson learned to make the effort to engage. That's number one. So fortunately, we're able to average. We have the 18 months. The downside is that if we do need to make supply chain changes because it turns out we're not going to qualify in those 18 months, we need to do it now because there are safety critical parts that could take a year to resource. So I'm sure like everybody, you know, some suppliers are thinking, oh, well, you've got some time, or you got that 6 months grace period. Yeah, but if we have to make supply chain changes, I need to know like yesterday. So that's been helpful, at least, that we do have the averaging, but we're still pushing for timing. And then the one other transition tip I wanted to share is we use a tool called Trade Automation to do our solicitation and our analysis. Like all trade tools and all of us, they're still trying to figure out the rules. So obviously, it's not live today. So we can't solicit suppliers today for USMCA because there's still a process for this tool to be upgraded. So we're having to manually solicit suppliers, and I understand from others in the industry or across, like from other consultants, that that's very common, that a lot of companies are stopping critical work to manually solicit and manually gather data. So it's a real challenge, I think, for the entire trade organization, the time this is taking, the manual effort, the risk by doing it manually. But that shouldn't stop us. So obviously the tip there is, if you gotta send some emails to your top suppliers before your tool is ready, that's probably the right step.
Steve, do you want to add anything in terms of sort of regulatory opportunities or software tools?
You know, just to really say a couple of things. Really, the second what Asha was saying, I think that averaging is an option that's available for vehicles. She said she's using it for their vehicles, their off-road vehicles. It's available for all vehicles and a wide range of parts. And it was available, as Asha said, with NAFTA, and was continuing with USMCA. I just think I think it's what we're going to find is that it's going to be used more by parts suppliers than it was under NAFTA, simply because the rules are more strict than under NAFTA. They require more content, North American content, for a lot of parts to qualify. So I think we are going to be seeing that it's used more in the automotive space. And I just noticed that one of the other bullet you have up is the informed compliance, and I think that this was something that Customs has offered, and I don't think they defined it as clearly as what a lot of importers were looking for. But I think what it does do is it gives a little bit of breathing space, just a little bit. I don't want to overemphasize how much breathing space it gives, but I think it gives everyone a little bit of space to catch their breath and say, okay, I mean, we have a little bit of time to go out and collect our USMCA data from our suppliers to validate our calculations. And if we think the goods qualify, the Customs is saying go ahead and make the claims. And then if you make some assumptions that are proved to be wrong, you can pay the duty later, and it's just the interest, and you don't have any risk of penalties. So I think that's given everyone a practical tool for the very short term to try to make this transition. Because we just, to try to get everything, in a month's time to be able to certify for USMCA is just for most companies, it's just like, it's just way too short of a time frame, especially when everyone was used to like 3 months or more to be able to get all this done, on top of there being new rules. So I think that's something that'll be, I think, utilized pretty extensively for this, for this ramp up period. And giving some real practical help to companies to try to get to where they need to be for USMCA certification.
Alejandro, is there anything unique to Mexico that you would like to add?
Well, here I think a lot of the industry, of course, of manufacturing and assembly is based upon duty deferral programs and requirements that were established under them already called for a series of software that that of course obliged you to follow up on all your raw materials, intermediate goods, etc., that were put there. So that must be extended, and where I think we will see a lot of the issues will be, to Ash's point, in low-tier suppliers that are more independent and local. I think a lot of the companies here that are subsidiaries of multinationals have started to put this in place already jointly with their home companies, but this lower tier may struggle more a bit in getting this type, and not necessarily where they're using the average methodology, etc., and all these tools that were already in place to a degree.
I'd like to say one more thing before we go from this slide, if that's okay, on the multidisciplinary team. So prior to USMCA, my team handled a NAFTA qualification pretty independently. We would escalate the sourcing if suppliers didn't respond. But other than that, we kind of did our thing and things qualified. With USMCA, the rule changes and concerns around, while it's harder, are we going to qualify? And there's a lot of money at risk. This became a top priority. So between our EVP of supply chain and our general counsel coming together, we developed a very cross-functional project team. We meet weekly. We have executive report outs at least monthly. It includes sourcing, engineering, the team that decides what's manufactured where, the team that decides in-source versus outsource. We have never had so much love and attention. I love it, I hate it, but it's been really successful in getting all the ideas on the table. Finance is involved. Are we using engineering costs appropriately? Should we move expenses? So it's really been insightful, I think, for the entire company on how complex free trade really is and how important it is to the company, given for at least Polaris, the dollars that are at risk. So great opportunity to get more visibility and a lot of people really interested in free trade.
And Asha,
I'm sorry, to Asha's point, I guess it's compliance, 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 no? Again, because what we've seen from a pragmatic viewpoint here is companies, still 2 weeks ago, we received a verification of origin proceeding for a client, for example, and we realized suddenly that the proceedings, even for issuance of certificates of origin under NAFTA, had lagged behind in compliance. No? So now you have to make even doubly sure that you comply, no? And that will call for a lot of intervention of the multidisciplinary team. I agree, because we need more engineers into this, at least from our perspective in this side of the border.
And Asha, for those listening who would love to have such an interdisciplinary team, how did you build the coalition and educate people and bring them on board?
I mean, it was thrust upon us, but I'm really glad it was. You know, it was primarily because we raised to executive attention that if we don't qualify, it could mean a whole lot of money, and the rules are different. It is harder to qualify. The whole idea of USMCA is that there's more North American content, and trade compliance is the team that analyzes. It's these other teams that actually make decisions that impact where product's made and what it's made with. So just that message alone on the risk really prompted our executive leaders to say, how do we get our arms around this? And well, we need these teams to engage and to really own the analysis, come to the table with solutions. It's been a, push and pull, but really educational, for my team as well, just understanding more about what can be sourced outside of North America and what can't. I mean, really hard to find an engine that qualifies. Those are the types of things that we've learned too.
Yeah, and Francesca, we went through a similar exercise, and I can say I think a lot of other companies experienced it too. And that the profile of the customs function in my organization has changed. I mean, as is much more interactive now with the rest of the organization. And there's a much larger commercial component to it and a sourcing component to it. And I think we looked at it in different ways, but we had to look at how do we boost up our North American content to meet the stricter rules. And that was a challenge. But also too is that we recognize that there's going to be a greater interest that we have, but also our customers have in our product qualifying. You know, that there's going to be a commercial interest in our customers, like the automakers, in sourcing originating product, because they too need more North American content for their vehicles to qualify. So I think there's that element to it too. And I think that on the sourcing, I think Ash is absolutely right. It comes down to a question of who can and what can you really resource. There are limitations to it. And I think everybody looked at it, and we had a lot of suppliers that kind of took it upon themselves to say, we can make ourselves more attractive to our North American customers if we set up manufacturing in North America. They didn't need to be prompted necessarily. So I think it was just a whole exercise that started that's going to continue. I think we're just really starting it. I don't think it's ended by any means. I think this is going to continue to be an issue where it's if and how you can get, in a commercially viable way and a cost-effective way, more North American content. This is going to continue. It's just really starting in many respects, and there's still a lot of I think possibilities there that are going to play out over the next few years.
Are there any products that you're looking at, you're getting the information from suppliers, and you're thinking, we just aren't going to be able to make this work, at least not right now, based on our current available sourcing options?
Is that question for me or for anyone?
It's an open-ended question.
No, I think it's we have a range of products, but I mean it's a challenge for us because with some of our products we do have to source more North American content. There's a significant change in the rules. Others less so, other products less so, because the rule of origin hasn't changed much. But in some cases, we've really had to look at, like, that's the only way we can really make it work is to do some really very targeted resourcing, which we've been able to do. But I think it's definitely, I think it's a challenge for a lot of companies. I think it's going to really continue to be a challenge for a while. And how can you resource and to make it work? And I think you're going to have a lot of product potentially that just doesn't qualify. And maybe it isn't worth it necessarily. That's a possible outcome too, is that it just, commercially it's not cost effective to try to make the changes to make the goods qualify. And it's just, it's just more effective at the end of the day to pay the duty.
Yeah, I agree. We have always just accepted if suppliers say it qualifies or doesn't qualify, here's the RVC, the next, whatever the trace value that we need. Okay, fine. Not anymore. Now we are having to actually rank for every supplier that says this is not USMCA qualified. We need to meet with sourcing to say, based on what about goes into this product, is it feasible that they could get it to qualify based on the inputs? If yes, we're going to be getting on the phone and having the supplier walk us through their bill of material and have them come back with a plan of what's the cost and time to get the part to qualify. But I agree, there are certain parts that will say, well, we know it would be impossible, so they may be high value, but we have to put them aside, but that may mean we have to go 5 more deep on the ones that are a potential. So it's work that we've never done before, and it's conversations with suppliers that are really new, that just have not occurred in the past.
We are right at our time frame. Any of the panelists, would you like to add one more comment before we sign off?
Well, I guess from my end, it's just, it'll be very interesting to see enforcement, how that will come about here in Mexico, how quickly the authorities shall react. And these new provisions, especially from the labor side, will be interesting to see. there's a time lag there between the actual labor reform under our local laws and this coming into force of the new provision. And that may be an issue from the union and collective bargaining arena. So that will be one area of concern that is going forward that must be addressed by Mexican companies almost immediately.
Thank you. So if you have any additional questions after today's webinar, please feel free to reach out to your current Thompson Hine or Santa Marina lawyer. If you're not a current client, please contact one of us and we can discuss options, to address your questions. And if you are not currently receiving our updates and invitations, we invite you to go to the Thompson Hine website and register to receive our mailings under the Publications tab. Thank you all for your interest in attending today's webinar, and enjoy the rest of your day and the holiday weekend, and stay well. Thank you very much.
Bye-bye.
Bye.